You're on bond for this DWI. You've been on bond since 2019, and now you've picked up a couple felonies out of state.
That was
I don't want you to talk about the case. My only concern is while you're on bond in this case, you're supposed to behave yourself. You're not supposed to pick up any new cases, and you pick.
Hold up. This is a major moment. The defendant's been out on bond for a DWI since 2019 and still managed to rack up multiple felony charges out of state. That's not a small slip-up, that's a full-on pattern. So here's the real debate. Should the judge still show mercy, or does breaking bond trust automatically lock in your fate? What's your take, redemption or consequences?
A couple felonies out of another state. Are we supposed to reward you for picking up new cases? What else has he done, Ms. Ziegler, since 2019? Two cases? One case?
I believe it was just one case from October.
Why should I not revoke his bond and put him in jail now? He's on bond for this case. He's been on bond and he now picked up a felony in another state.
And I do understand that, Your Honor. I think that just in the interest of justice, I think that given the facts, and obviously we're not here to discuss what's going on in Louisiana.
Are you representing him in Louisiana?
I'm not. No, Your Honor, I'm not representing him in Louisiana. But obviously, I'm in contact with counsel there. I think, without getting into the details of that, Your Honor, I think it's an extraordinarily interesting law that they have, or laws that they have in Louisiana, where what we would consider as a technical civil dispute somehow gets transformed into a criminal matter in Louisiana. Obviously, the French civil law, I don't even attempt to try to understand those rules, but it is more of a civil dispute more than some type of fraud that was taking place in this situation. I think we're very optimistic that that's going to get resolved. Obviously, I've just been on this matter, Your Honor, focusing in on the DWI matter, Your Honor. It was a crash, but the facts as set forth in the incident report, Your Honor, he did not collide with another vehicle. He didn't hit a pole. He didn't hit a tree. Instead, based upon the report, he swerved to avoid.
All right, time for a quick legal breakdown. The defense is arguing that the Louisiana case was just a civil dispute that turned criminal. And in states like Louisiana, with their French-style civil law system, that's not impossible. It's rare, but it happens. Still, you can see the judge isn't convinced. So here's the question. Should out-of-state legal quirks really influence bond decisions back home?
Coming out of a private driveway. So to avoid from hitting that vehicle, he swerved, hit a curb, which resulted in blowing out the tire on his vehicle. The car had other people in the car, and obviously that creates some issues, as Your Honor could imagine. But this was not a DWI case where he's driving down the road 60 miles an hour and crashes into someone or anything in that realm, Your Honor. For those reasons, I think in the interest of justice, having him to go to jail, not that that's what's on the table right now, but having
it is on the table now because he picked up a felony case while he's on bond for a case, right? He's been MIA for 5 years, and now you want some kind of in the interest of justice. The interest of justice is that we protect our county. You're on bond for this case. You've been on bond for 5 years. You've been gone. Now you pick up a felony case. Are we supposed to patch on the back? No, I'm revoking your bond. I'm taking you into custody. What are we supposed to do? You know, you can't just be gone and then you pick up a felony case in another state. I mean, what are we supposed to do? You know, really. But you have to understand that actions have consequences, right? You're an adult. Your failure to act, your failure to come, you're picking up a new case. Now, I know that you say it's a civil dispute, but they found enough probable cause and a grand jury indicted you. That's usually between 9 to 12 people that sit, have completely neutral and detached, sit, listen to facts and determine, hey, we think this person may have committed a felony offense.
It was original arrest warrant, and it's still, the DA still hasn't accepted charges.
And Your Honor, again, not getting into the details, and it's not, we're not here to try to resolve the Louisiana.
I get it. but
Sorry.
go
No,
ahead.
Your Honor, and I'm just, let me suggest here, Your Honor. What happens in Louisiana is this. There's a civil dispute between the parties, what we would call a civil dispute. And as a result, in Texas, what we would do in the event if a contractor or subcontractor is not paid, we place a lien on someone's property. In Louisiana, if that same transaction happens, the homeowner, now obviously there would be consequences, there may be consequences for that homeowner, can call the DA and say, no, this guy ripped me off. Notwithstanding the fact they owe him money, this guy ripped me off. And if the DA there,
Because I've had two people that have done that to me.
well, Your Honor, over there, Your Honor, over there, that it turns into a criminal matter. So again, we think it's going to get wiped away. I know we are this close to getting this matter resolved. And I think in all respect to the court, all respect to the bench, Your Honor, not being here for 5 years is a major issue. This matter should have been resolved a long time ago. Had I been brought in 6 months ago, it would have been resolved 6 months ago, Your Honor. We're just asking that, one, if there could be a level of grace and mercy extended to Mr. Williams at this today, I think we could get the matter resolved today, Your Honor. Obviously, I haven't had an opportunity to look at the medical records. I haven't had more than 30 minutes to even examine the record.
And you know, I'm sorry that you're being placed into this precarious position now. And the facts are what they are, right? If we could make our own facts, we would all win. But at times, the bill comes due. That is today. But if you think that you can just continue to get away, jump 5 years, come back, and while you're out there, you pick up a felony case as well. I can't because I would be telling you that behavior is okay, and it's not.
And this is the breaking point. The judge's patience is gone. 5 years wasted, a new felony added, and now the talk shifts to rehab or custody. It's the ultimate collision of accountability and second chances. Do you think the judge is being too tough, or just doing what's needed to protect the public? Drop your opinion. This one's a moral tightrope.
Are able to, work something out, by all means, I'm okay with that. But I can't in good conscience, when he's been gone for 5 years, he picked up a felony, whether it's in Abu Dhabi, whether it's in Alabama, Oklahoma, he's hopscotching states, but he goes with you. If you want to work something out, I'm happy to whatever you guys want to do, but it's only fair. It really, but like I said, if you guys work something out, I'm happy to entertain whatever you guys want to do. But you guys talk, don't
Understand.
not here. He's going to take him back. I'm going to let you guys talk, see what you want to do. I'm all ears. I'm always open to anything else. But the bill comes due. All right. Take your time. There's no rush. Yeah. I'm not going to continue to play this game with you. Mr. Castro, I'm not doing this again.
Sorry.
Look at me.
Sorry.
I have people that continue to come back over and over and over, and all they,
Sorry.
I want you to look at me, because this is going to be a life-changing moment for you right now. They keep coming back. They keep pleading guilty. They keep coming back. They keep pleading guilty. And it's a revolving door. The door stops today. Do you understand? If you are unable to not pick up cases, then we are going to delve deep next time as to why it continues to happen. If that means putting you in a rehab facility, in a dual diagnosis residential facility for figuring out mentally why these things keep happening, then so be it. The door stops today.
Yes, sir.
Do you understand, Mr. Castro? I know you well. And in the last 2 to 3 years, we're working at least. Since you and I have been together. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 stops today. If you are unable to exercise self-control, we are going to dance a lot together next time. Do you hear me?
Yes, sir. Yes, sir.
Hear me loud and hear me clear, Mr. Castro, because I'm not doing this again.
Yes, sir.
We will have issues next time. Do you understand?
Yes, sir, I do. Yes.
You now stand charged with theft. Hey, how many is this anyways? Is the next one a felony regardless?
I don't believe so, Judge,
I believe there's a
actually.
part that's Judge.
You run an NCIC for me, please, Morgan. Let's take a look to see. Because I want to advise him properly as to, you need to understand that every time you plead guilty to an offense, it goes on your record.
Sir.
And when you pick up a certain type of offense consecutively and times, they can put it together and they can file a felony case on you, and you're looking at years instead of days. You now stand charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. They've offered you 6 days in jail credit for the 2. Any prior thefts, Morgan?
No, Judge, I'm not seeing any.
You're giving up a lot of rights by entering into this agreement.
Sir.
You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Mr. Castro,
Yes, sir.
I want the best thing for you, but it continues to happen. So somehow we're not getting through to you. And we need to get through to you so that you understand it's not okay to continue to pick up criminal cases. And in the few short years you and I have been together, we're now working 12 cases. This is not acceptable. What do we need to do to get it to stop?
Yes. But yes,
Shh.
I'm completely capable of these, and because it is so highly agreeable. So I'm on top of it myself as much as I would be able to. This place, it is interestingly confusing, but yes.
Well, let me tell you something. I have a couple people in here that have continued to come back. And what we have done is now have them in facilities trying to figure out why they cannot stop picking up criminal cases. I'm telling you, I've got probably about 4 or 5 individuals that have kept with me. You now are on my list. So heed this warning.
Yes.
Do you understand, Mr. Castro? How do you plead to the offense of theft? Guilty or not guilty?
Guilty, sir.
I will find you guilty. I will sentence you to the agreement. Good luck to you, sir. All right, Josh.
Josh.
Oh, good morning, sir. Number one, don't email me. That's not a good thing, man. Really, because I'm supposed to be neutral, detached. So I don't know what happens until if it goes to trial. So just, it's okay. Just from now on. All right. So you now stand charged. You picked up a terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. You cannot afford one, one will be appointed to you. I don't know what happened in this case. I'm just now seeing it for a first time. All I know is that you're on bond for this case, for another case, and now you picked up a new one. So let's go forward and
Officers were dispatched to a residence in Harris County, Texas. Complaining witness showed officers text messages ranging from May 2024 to November 2024, where the defendant sent her photos of guns and threatened to shoot the complaining witness and their child. Defendant also stated he would shoot up her house and hoped that he would hit her and the child.
when is the statement that he was going to shoot up the house? Was that from May and that he's just investigating this? Because that's not a terroristic threat. But if it was an active thing where he was.
Well, it looks like the offense, so per the offense report, the actual offense took place on November 8th.
Okay.
But I believe that she showed them old text messages.
Okay, so when was that statement that I'm going to shoot up the house and yada, yada, yada? Sure, take your time.
And Judge, while they're looking, it's not alleged when the statement was. And not only that, it's not reported till 3 days later. Furthermore, in the reviewing the text messages that have been submitted, there's not a single text message that has that specific threat.
Well, I don't know. I mean, it's the state's burden to show, I don't know, but terroristic threat has to be an immediate fear of harm.
So I don't see an actual date in the offense report. I personally have not reviewed the text messages in this case, Judge. I don't see a date of the actual threat.
That's not a good thing. I mean, who knows when that statement was made? Could have been made 2 years ago. Could have been made yesterday. Yeah, I agree with you, man. I mean, if you don't have anything else, then that's it. Okay, I'm going to find no probable cause. Mr. McCollum, we're not asking much, man. We want our streets to be safe. I'm going to do everything in my power to protect the streets, right? If I find that you're a problem, if they call back and it continues to happen, it's not going to go well. Life is way too short to live in a 6x9 box. There are a lot of great people in life. There's a lot of bad people in life. And if you have a relationship with a so-called person that brings out the worst in you, then don't have a relationship with this person. There's a gajillion and one fish in the sea. It's not worth it to have someone rap you so bad that you make and say things that make you go to jail. It's not worth it. Do you understand? Now, don't have contact with this person because it's just not going to end well. All right. All right. So I'm going to continue bond. I'm not going to revoke your bond on this case now because I'm finding no probable cause, but just behave. It's not hard. Be nice. All right. Okay.
Judge.
For sure.
Morning, George.
He speaks both English and Spanish, Judge, but he says he may feel more comfortable in Spanish.
I don't know if it's going to be a good Mr. Martinez. I'm not happy with you. I asked you one thing. I have here that you're tampering with your device. Any alcohol detected?
No alcohol protection, Judge.
What, do you know the?
Me?
But either, what?
So what he tells me in terms of the, I guess, potential tampering, he said was, the device was wet around his skin. So he used, in fact, he told me yesterday, he used a leaf blower to dry it off. That may have been one of the times it was tampering.
That would cause a tamper. Environmental factors like that don't cause something like that, and that would be such a short period of time. I have the durations of the hours on that little sticky note, and I can't remember them off the top of my head. But tampers are confirmed after 8 hours with low alcohol detected, so therefore a leaf blower would, if anything, it would show a spike in tamper, but nothing to cause a tamper.
So what we have here and what I have here, your first tamper was on October 28th, and it was an 11-hour tamper. So more than likely, what we find is that people put things in between the scram device and their ankle to subvert the machine. Your second violation that we have is on November 11th at 3 in the morning, and that one is a 9-hour tamper. How does that happen?
I have a solution.
So, Judge, the only thing I have is the violation report. I don't have any other documentation from you guys showing exactly, well.
The problem is that there's only,
But in terms of saying that it was for 11 hours.
I have the scram report, counsel, I can send it over to you. if you'd like.
but, and if you want to take time to look at it, but what we find, it's really, there's no cameras, so it's impossible to really look at what they're exactly doing, but all we know is that they're breaking the continual skin and device contact. And how they're doing that, I wouldn't know. Only he knows. But all we know is that the tamper is for a duration because the contact is lost somehow. Piece of paper, could be that they're using a sock, however it may be. But all we know, it's for a certain duration and that it's a tamper and it remains constant for that entire period. So the machine is not able to test his leg.
Okay, yeah.
So I'm happy to give you the device. You will stay with me now and take a
I'd like
look
to
and
look
tell
at
me
it and talk
what you
about
think. Yes.
exactly what.
Yeah, I mean, I'm not letting him go.
I understand. I understand. Okay, so. I'll
So
get that and then
we'll give you the info now. I'm taking you into custody right now. I'll let you talk. I don't want him to go outside.
I understand. I understand.
But I'll give you more than enough time to talk.
Sure, okay. Okay, we'll talk afterwards.
Yep.
All right. Sure. And
Every case tells a story of choices, chances, and consequences. From old bonds to new mistakes, what plays out in this courtroom isn't just law, it's human nature on full display. So tell me, if you were the judge here, what would you do? Mercy or maximum accountability? Drop your thoughts below, and don't forget to like, share, and subscribe for more real courtroom moments like this.